I'm Meg Kinnear, and I'm here today with Professor Campbell McLachlan from New Zealand, and we're going to talk a little bit about the oral phase of an arbitration hearing. Professor McLachlan, we often think of arbitration as a written process. Can you tell us what you see as the main point of the oral phase of the arbitration?
Good morning, Meg. Obviously, the parties want a proper opportunity and deserve a proper opportunity to present their case orally as well as in writing. But there are, I think, a number of things that can be done in an oral phase that will really take a case beyond the stage that it's reached at the end of the oral proceedings. The first and most important element is to seek to identify what really are the matters in dispute. Often, by the time we get to a hearing, there are quite a number of matters that are actually common ground between the parties, which can be put to one side. And then there's an opportunity, therefore, to really focus on the contentious issues, to test the evidence on those issues, and to give counsel an opportunity to address concerns or questions that the tribunal might have for them about the nature of the case.
What tips would you have for counsel to prepare effectively?
Well, obviously preparing to present a big case in a short space of time contains a whole bunch of challenges. But there are things that I think that can be done of perhaps a rather practical nature that can ease the process. I'm a great believer in counsel, preferably by agreement between themselves, agreeing on a short file of contemporaneous documents, the core documents. Of course, the tribunal will read the rest of the arbitration file, but it often makes a hearing much more effective if, as one goes with the witnesses to the same key documents again and again, one can focus on those in a single file. So that's one practical thing. And then just thinking about the way you want to organize the hearing. There's limited time, so having an agreed hearing schedule is a very important factor.
How important or how much impact do you think the opening and closing statement have?
Well, oral openings provide a very valuable opportunity for counsel to summarize in very succinct form the key issues as they see them, given that the case will have gone already through a number of iterations in the written phase. For myself, though, I find particular utility in the closing statements. Oral closing statements can really enable the tribunal to see the true significance, as counsel would have it, of evidence given for the first time in the oral phase, and can link that evidence to the issues as they're presented by the parties, and also to give counsel an opportunity to properly address questions and concerns that the tribunal might have.
One of the other players at the oral phase is the expert witness. How do you best use the expert witness at that phase?
Expert evidence is a large feature of many big investment arbitration cases, and rightly so. Many of these cases involve quite complex technical issues. Often, if there's a damages claim, they'll involve complex economic issues. Now, the experts, of course, owe their primary duties to the tribunal and not simply to the parties that have called them. And they've also typically looked at the totality of the case in very great detail, often preparing reports that run to many volumes. But in my experience, the critical issues to identify with the experts are the underlying assumptions which they have been often instructed to use in preparing their calculations. And if one can do that, there is then an opportunity to get the experts to work cooperatively so as to be able to assist the tribunal by showing the tribunal how the application of different assumptions might work in the often very complex economic models that they've been presented. Remembering, of course, that tribunals are typically picked for their legal and not their economic expertise, but still the parties expect, in the event that the tribunal makes a merits finding in favour of a claimant, that the tribunal will be put in a position to produce a fully reasoned economic analysis.
And as a tribunal member, what are some of the things you think you and your co-arbitrators can do to make the oral phase most effective?
This is, of course, a two-way street. It's not simply a matter of counsel, it's also the responsibility of the tribunal, and typically, principally the president of the tribunal in preparing the case for hearing. So one aspect of that is to be proactive about the way in which the hearing will be organised, considering issues such as the order of witnesses, whether expert evidence is to be taken sequentially or together, and matters of that kind. So that's the first thing. The second thing is perhaps more intangible, but therefore just as important, and that is, I think, a matter of demeanour. I think it's very important in these cases that tribunals should show courtesy to counsel. For those of us who had prior careers as counsel, I think we're very well aware of the pressures that rest on counsel. And it's important in these cases to give counsel, therefore, a proper opportunity to consider questions from the tribunal, perhaps take instructions if necessary, so that the answers that are given are ones that are going to be the most useful to the tribunal. And then the third point is not so much a question about the hearing, but what then immediately follows. For myself, I'm a very firm believer in the value of the tribunal staying in the venue for the hearing for an extra day so that they can have a preliminary deliberation. Of course, that won't be the end of the deliberative process, but there's a precious opportunity there where the evidence is fresh, the issues are fresh, for the members of the tribunal to get together and to have a preliminary exchange of views. And in my experience, that typically radically shortens the deliberative process. It provides a basis. Not all issues will necessarily be agreed, but provides a basis for the tribunal to move forward.
Well, in one summary then, how would you suggest oral hearings, or what would you say is the most important virtue of the oral hearing?
Well, if I had to pick one single virtue, Meg, I would identify civility. I think obviously these cases are very important to the parties. Counsel naturally get very invested in the rightness of their client's case, but the tribunal is charged with a very important function by virtue of the consent of both parties to decide this case. And the most important thing is that the issues should be able to be aired in an atmosphere of mutual respect.
Thank you. This has been very helpful.
It's a pleasure.